the bill of review petitioner, the party who is aggrieved, who is saying they were denied due process, must support their bill of review with evidence beyond their own, hey, I didn't get service. You can't just submit a denial. Hey, judge, hey, sorry, I didn't get service. That is insufficient to prevail on a bill of review. You've got to have evidence, corroborative evidence from sources beyond that party's own testimony that some facet of constitutional notice was deprived. You got to be creative about how you get that evidence. It's not easy to get. Obviously, if the courts only had to rely on the party who claimed no due process, bill of review would be an easy burden. But it's not an easy burden. It's intentionally a difficult burden because there's a presumption about finality of judgments in Texas. In other words, if you blew off a lawsuit and you let a judgment be rendered against you, there's a presumption that the court should not save you from sitting on your laurels. There's really no other way to put it. You've got to overcome that presumption with corroborative evidence that establishes, corroborative evidence being evidence from outside the complaining witness, whether that be evidence from the other party, evidence from other sources, other witnesses. This is where these bill of review cases get challenging. Anyway, the point about the bill of review proceeding is that you've got to survive and convince the court that constitutional due process was not complied with. The only way to do that is to have corroborating evidence from outside the complaining party's own self-serving statement that I didn't get due process, judge. And then you're permitted to return the case to the underlying claim to both prosecute and defend counterclaims, affirmative defenses, original complainant's claims, the plaintiff in that original underlying lawsuit. Everybody is returned to their original starting positions and the case is reset, like a mulligan in golf. The most difficult and challenging thing about the bill of review is outside the claims related to due process. So if you're outside of that little box, the bill of review got just that much harder because then you have to establish it's not the fault of the bill of review petitioner. In other words, the bill of review petitioner was not lazy. In other words, the bill of review petitioner has an affirmative burden. It means they've got to carry a burden of proof to establish that they were not lazy, that they didn't disregard, that they didn't blow it off, that they were diligent in exercising. Moreover, the negligence of one's own attorney can be imputed to a bill of review petitioner. And what's scary about that is, let's say your attorney has a stroke. Wrong with that? You hire many fantastic practitioners are solo practitioners. They come highly recommended from friends, business partners, colleagues, neighbors, people at church, what have you, and they're fantastic lawyers. Have a stroke, have some medical emergency, they're out of pocket, deadline gets missed, now you're in bill of review land. It literally could happen to anybody, but that lawyer's negligent. If that lawyer was negligent, if that lawyer was simply overbooked or had a medical emergency and didn't make appropriate contingent plans and ignored due process, ignored process of suit, such that a default judgment was rendered, failed to answer discovery, and a motion for sanctions was filed, that motion for sanctions strikes all pleadings, the other party wins by default. That's the kind of stuff that can happen. It's those scenarios where the bill of review becomes very challenging because the negligence of that attorney can be imputed to the bill of review claimant.